Start the session, Mr. Deepak.
Sure.
Good evening, a warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today Mr. Deepak Bhaskar, Advocate, High Court of Karnataka. Mr. Deepak, it's a pleasure to have you with us today. Welcome to the webinar.
Thank you.
Now it's time to introduce our today's speaker. Mr. Deepak Bhaskar is an advocate and is the founder of Deepak Bhaskar and Associates. It's a dispute resolution and labor advisory chamber. Mr. Deepak obtained a bachelor's degree in law with honors from the University of Warwick, United Kingdom, and he also holds a master's degree in intellectual property law as well as constitutional law. He has the distinction of having assisted the permanent mission of India to the United Nations in various assignments before the Security Council of the United Nations at New York. An avid student of literature, law, and policy, Deepak taught a seminar course on law and literature at the National Law School of India University and has also authored an article published by the World Bank on the ease of doing business in India. Deepak is also the founder of Nipani Foundation, a non-profit organization which seeks to enhance the occasional abilities and skills of juvenile delinquents. Mr. Deepak, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Before you can start up with the topic, I think it would be pertinent to speak about your NGO for a few seconds, and then you may proceed with the topic. Over to you.
Sure. Yellarigu namaskara. Thank you, Trivikram, for this very warm welcome and your invitation. It's a great pleasure to join you and all the participants in this webinar. And you were just pointing out that this is the 149th such webinar. It's a fantastic achievement. So many congratulations to you and the Advocates Association, of course, to the participants who made it possible. Just a brief word about the NGO. So I'm someone who essentially is very interested in labor planning and policy, and it's one of those subjects which is at the confluence of law, economics, public policy, and that's why it attracts my fascination. Now, as you will know, a lot of juvenile delinquents, a lot of children who take to crime, unfortunately do so because of large socio-economic reasons. And unfortunately, they do not have the means or the resources to enter into formal employment or get education or get any skills. So what the Nipani Foundation is about is to try and bridge the gap between their socio-economic disparities and their future, which otherwise is a bleak recurrence of criminal activities. So with various stakeholders and partners, we try to enable these juvenile delinquents to come into a better form of life by having certain vocational skills, certain capacities by way of which they can take on technical jobs or apprenticeships and thereafter build their life. So to start with the topic at hand, as I was saying, it's a topic which has attained extreme pertinence, especially in the past few months. I'm sure all of us advocates have been approached by various clients, both employers and employees, those at the receiving end of termination orders, those who wish to understand how they can terminate the services of their employees and what the risks, underlying risks of these measures are. So this is a topic which I thought I would engage with all of you today. And hopefully it will be interactive, and it'll be my endeavor to take on board as many comments and questions as possible. I understand we have a Q&A at the end of the session. So in order to to understand the topic, which is an overview of the law and procedure of termination of employment, I must caveat this. This session will cover the termination of employment insofar as the private sector is concerned. I understand Mr. Bhagwat had recently undertaken a session on Article 311 and civil servants and the service rules which govern them. I would recommend all the participants here to watch that video. It's a fantastic exposition of the law on the subject. So, uh, a fundamental problem, a hypothesis, if we can frame it as such, is, let's say there is an employee by the name Deepak. Now, Deepak works for an IT company. As most of us in Bangalore will have friends who are invariably involved in the ITS sector. Now, the company hand reaches out to any one of us here and says, "Look, we have an employee we'd like to get rid of, and how do we go about this?" Now, it's not uncommon to be lost in this wild maze of labor laws, largely because labor is a concurrent subject, as we know. Both the state and the center are able to legislate on the subject. And by virtue of this, we have multiple laws. And these multiple laws can sometimes overlap, they can sometimes be contradictory. So the question that arises at the very first instance is, as lawyers, how do we understand the nature of employment? And there is, I think, a great starting point is to always keep that in mind when posed with a question as to how to advise a client on either how to terminate the services of an employee or to advise the employee as to what their rights are. A fundamental starting point is to understand the relationship of employment itself. There are many cases, a great line of judgments right from, if we look at backwards, from Chief Engineer Heidel Project versus Ravindranath, which is in 2008, AIR 2008, Supreme Court 1315 judgment, and judgments prior to that, whether it's Premier Automobiles, Jitendranath Biswas's case, which really go into the laws that govern different kinds of employment relationships. Broadly speaking, we can summarize employment relationships into three. The first would be, as I started out by saying, Article 311, civil servants. I will add to that also employees of public sector undertakings who will have their own service rules. We are not concerned with that arm of the issue. The other two are basically those who have a relationship of employment purely by way of contract. And the third final limb are employees who are governed by labor laws. Now, the immediate corollary of that is, what are these labor laws that govern these employees? Broadly speaking, there are two. As I said, labor is a concurrent subject. And if we look at the two main legislations which operate in the field, one looks to the Industrial Disputes Act of 1947. And of course, there are state-specific Shops and Establishments Acts. Now, in Karnataka, we have the Karnataka Shops and Commercial Establishments Act of 1961. I will advert to both of these legislations to first understand what are the concepts of employment, employee, who is an employee, what are the criteria to determine the relationship of employment, before we try and address the founding problem which we set out at the beginning of the webinar, which was, we have an IT company here who's reached out to us and said they would like to terminate an employee. What is the advice we would give them? How do we go about it? So a very fundamental starting point would be Section 2S of the Industrial Disputes Act, which I will read out for the benefit of all of you here. Section 2S is a very broadly worded definition A workman means any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or for reward, whether the terms of employment be express or implied, and for the purposes of any proceeding under this act in relation to an industrial dispute, includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute, or whose dismissal, discharge, or retrenchment has led to that dispute, but does not include the list of exemptions. Such person who is subject to the Air Force Act or the Army Act or the Navy Act, such person who is employed in the police service or as an officer or other employee of a prison, or who is employed mainly in a managerial or administrative capacity, or who being employed in a supervisory capacity draws wages exceeding 10,000 rupees per mensem or per month, or exercises either by the nature of the duties attached to the office or by reasons of the powers vested in him, functions mainly of a managerial nature. Now, that is quite a mouthful of a definition. It starts off in a very broad, sweeping manner by talking about any person who is employed in any industry to pretty much do any work. Of course, the exceptions we've looked at: Air Force Act, the Army Act, the Navy Act, persons who are in the police service or officers of the prison. But what's really interesting and applicable to us in our daily practice are persons who are employed in a managerial or administrative capacity, who will not constitute workmen, or those who perform supervisory activities and draw wages which exceed 10,000 rupees per month. Now, the interesting part about this definition and why it's important is that the Industrial Disputes Act by and large applies to workmen. If there has to be an industrial dispute, it has to be by and large, you must have workmen involved in that dispute. Of course, there are instances where you will, there can be an industrial dispute without workmen, but you will see in practical life that you will not have industrial disputes without workmen. It's usually workmen versus the employers. Now, the Industrial Disputes Act does not have the definition of termination. What we have instead is a concept known as retrenchment. Now, this concept we will find in section 200, which again attains extreme importance, and I will read this out. Now, please also note the broad nature of this definition of retrenchment. Retrenchment means the termination by the employer of the service of a workman for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action, but does not include the voluntary retirement of the workman, the retirement of the workman on reaching the age of superannuation if the contract of employment between the employer and the workman concerned contains a stipulation in that behalf, or termination of the service of the workman as a result of the non-renewal of the contract of employment between the employer and the workman concerned on its expiry, or of such contract being terminated under a stipulation in that behalf contained therein, or termination of the service of a workman on the ground of continued ill health. Again, quite a mouthful of a definition. What is retrenchment? Retrenchment is basically the termination by the employer of the service of a workman for any reason whatsoever. The exceptions are where that termination is by way of a disciplinary action, where that termination is, say, on account of voluntary retirement, retirement on account of superannuation, the expiry of a fixed term contract, and continued ill health. What is really applicable, or what we see most often, especially in the IT, ITS sector or manufacturing sectors, is that the exception to retrenchment, especially for disciplinary purposes, attains a lot of prominence, and the process as to how to deal with those disciplinary exceptions, I will get to in a bit. So, broadly speaking, the ID Act provides for a procedure for retrenchment. You have a division between between industrial establishments which employ up to 300 workmen, which is now, it used to be 100, it's now 300. And you have a law which operates for those establishments which have 300 or more workmen. Now, this procedure of retrenchment is set out in section 25F, where there are certain conditions precedent to the retrenchment of workmen. Now, 25F simply says, no workman employed in any industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by that employer until. Now, these are the three conditions that need to be fulfilled before an employer undertakes the process of retrenchment. Firstly, the workman in question must be given 1 month's notice in writing, whereby the reasons for retrenchment are spelled out. Along with such notice, he must be paid wages for the period of the notice. Sorry, as an alternative, he must be paid wages. So it's either notice or wages in lieu of notice. And he must be paid what is known as retrenchment compensation. Now, retrenchment compensation is essentially calculated at the rate of 15 days of average pay for each completed year of service. In certain cases where the threshold is beyond 300, the permission of the appropriate government is required, which is usually the state government, unless it's a central government undertaking. And where it's below 300, only an intimation need be provided, no prior permission is required. So this is the position broadly insofar as the Industrial Disputes Act is concerned. You have a retrenchment process, and that retrenchment process applies to a workman. Now, how do you determine who is a workman? Largely, the first question one would be asking their client is, please tell us what is the role and responsibilities performed by your employees. You would be surprised to note that today, by and large, most software engineers, most people who perform roles which pay very well, fall under this broad definition of a workman. And Bangalore is one of those few places in the country which has an IT workers union. Typically, as all of you are familiar, the concept of unionization was confined to the manufacturing sector, to plantations, to coal fields, to mines. But now IT workers have unions because most IT employees fall under the ambit of this scope of workmen and therefore have recourse to the protection given to them by the Industrial Disputes Act. Now, I will just set the ID Act aside for a minute, because our problem now, if you are advising the company as to how to proceed with termination, is not just to look at the ID Act, but also to look at the state-specific Shops and Establishments Act. Now, section 39, of course, there is the definition of commercial establishments and what is a shop. And again, these are sweeping definitions. Just for reference, I will read out the definition of commercial establishments in the Karnataka Shops and Establishments Act, which is section 2E, which says a commercial establishment means a commercial or trading or banking or insurance establishment, an establishment or administrative service in which persons employed are mainly engaged in office work, a hotel, restaurant, boarding or eating house, a cafe, any other refreshment house, a theater, or any other place of public amusement or entertainment, and include such establishments as the state government may by notification declare to be a commercial establishment. So again, it's a very broad definition. Section 39 of the Karnataka Commercial Shops and Commercial Establishments Act is what is pertinent to us. Now, there is, and we will find most of the Shops and Establishments Act are fairly similar in that they require that there be a reasonable cause prior to effecting any termination. What you will notice, the difference between the ID Act, the Industrial Disputes Act, and the Shops and Establishments Act is that there is no mention of a workman in the Shops and Establishments Act. There is no mention of an employee in the Industrial Disputes Act. For those who have gone through the the Industrial Relations Code, there is a mention of both employee and workman. It's a problem for another day in terms of how these definitions overlap. But coming back to section 39 of the S&D Act, 39.1 says no employer shall remove or dismiss an employee who has put in service under him continuously for a period of not less than 6 months, except for a reasonable cause and unless and until 1 month's previous notice or pay in lieu thereof has been given to him. So let's contrast section 39.1 and 25F, which is the condition precedent to retrenchment. What is common in both acts is 1 month's written notice or wages in lieu thereof. The additional requirement by way of the S&D Act is that the termination must now be for a reasonable cause. Of course, what is deemed to be reasonable has been examined in many cases, and courts have ultimately held that it is a reasonable cause has to be looked at in the context of the business. It varies from case to case, and there are certain examples which we will get to. Now, the exception to this notice of dismissal, or rather the exception to the notice of dismissal along with reasonable cause, is misconduct. Provided that where misconduct of an employee is brought on record with proof at an inquiry held for that purpose, he shall not be entitled to the notice or pay in lieu of such notice. Now, this you will find is a very common problem where employees are suspected of misconduct. Employers want to terminate the services of such employees. The question is, sometimes they would have conducted a domestic inquiry, sometimes they would not have, and we will examine the implications of both. Now, the question here that we need to look at now, largely we've gone through what the legal provisions are. I will also just make a mention of the Industrial Employment Standing Orders Act, which sets out the service conditions, so to speak, what constitutes misconduct, what are the terms of service in an industrial establishment. Those are in an act known as the Industrial Employment Standing Orders. Now the question is, once we have informed our clients that, look, there are two statutes at play here. One is the ID Act, one is the S&D Act. It is now important to identify whether your client fits into one of the statutes, fits into both of the statutes, or perhaps is exempt from both of the statutes. Accordingly, what this helps us do, irrespective of whether you appear for the employer or the employee, what this helps you to do is it helps a lawyer determine the nature of the relief at hand or the nature of the risk involved in suggesting a strategy, and also helps you determine the forum at which any litigation will happen, any challenge to the termination order, because there are various challenges at each such forum. So if we were to look at, I will go back to the Industrial Disputes Act. I mean, industrial dispute is largely raised at the instance of trade unions or a substantial majority of the workmen. By and large, from the inception of the enactment till 1965, till 1st December 1965, when Act 35 of 1965 came into force, only a substantial majority of workmen or workmen through their trade unions could raise what were known as industrial disputes. Now, these industrial disputes could be in relation to violation of the service conditions. It could be in relation to retrenchment. It could be in relation to lockout by the management or strikes by the workmen. It could be in relation to unfair labor practices. So the one aspect that was missing was one person who got retrenched or one person who got terminated could not raise an industrial dispute under the ID Act. This problem was fixed in 1965 with the insertion of Section 2A. Now, Section 2A allows for an individual dispute to be deemed as an industrial dispute. Section 2A read with, there's a Karnataka amendment to Section 10, subsection 4A, which permits individuals to also approach an industrial tribunal or a labor court in respect of any termination which they believe is unjustified. Now, coming to the Shops and Establishments Act, any Section 39(2), I will read this out, empowers an employee removed or dismissed under subsection 1 to have a right of appeal on the ground that there was no reasonable cause for the removal or dismissal, or that he has not been held guilty of misconduct by the employer. Now, the process under each of these acts, under the ID Act, either there is, upon the presentation of a claim or a complaint, there will be a conciliation process. If that conciliation process between the workman and the employer fails, there is a failure report. On that failure report, there will be an order of reference to the state government, whereby by the state government, where the state government will empower an industrial tribunal or labor court to take up a certain dispute. In the Shops and Establishments Act, one can directly appeal the order of termination before the relevant labor authority. And that the first thing that a labor authority will look at is whether there was reasonable cause. Now, I spoke about the exceptions both under the ID Act as well as under the Shops and Establishments Act. One common exception is misconduct. And misconduct is a very commonly recurring theme in terms of termination cases. What courts have done over years of jurisprudence is they have read into the process of termination the requirement of due process, and they have mandated that a reasonable opportunity be provided to the workman or the employee to be heard before any adverse action is taken against them. And in doing so, a category of termination subsections have come into play. For example, reasonable cause could mean, under the S&D Act, reasonable cause could mean, say, if your business is not doing well, if the company is on the verge of closing, there is financial liquidity issues. As we've seen during the past few months in the pandemic, many establishments have closed. Or say under the ID Act, although there is no reasonable cause requirement, courts have said, for example, misconduct. You need to have an internal inquiry. That internal inquiry, there is a process whereby at first a charge sheet is provided to the delinquent employee, whereby they are informed of the charges against them, the charges of misconduct against them. It could be habitual absence from work. It could be neglect of work. It could be theft, violations of the standing orders. So it is important that the employer offers the workman or an employee a chance to explain himself. And the employee will then provide a written explanation. Where the employer is unsatisfied with the nature of the explanation received, there is an inquiry which is constituted. This inquiry is undertaken by an independent, impartial officer. Parties will have the option, when I say parties, I mean management and the workman will have the opportunity to lead evidence against each other. There's a process for cross-examination of and appreciation of the evidence at hand. And then finally, the inquiry officer presents a report and submits it to the management of the company to take a decision as they see fit. Even here, courts have read into such a process a doctrine of proportionality. If the misconduct is minor, one cannot justify it by termination. Perhaps in some cases, a warning letter suffices. So it really works on a case-to-case basis. Further, courts have looked at different, especially in the IT sector, most of you would have advised your clients on performance improvement plans, where, say, for example, in our example of the IT employee who is on the verge of being terminated, a company, one of the questions you will ask your client, in addition to understanding the roles and responsibilities of that employee, is what is the reason you want to terminate that employee? Now your client could come back and say, I would like to terminate this employee on the grounds of misconduct, in which case you will suggest the process that I just laid out. Or they may say, no, look, he is a habitual poor performer. His performance is not up to the mark, in which case it's incumbent on us to explain the process behind poor performance. Courts have held that, an employee who's a poor performer in one place is probably a star performer in another environment. Therefore, it cannot be subjective. Therefore, the process that courts have called out is that the employee who is accused of performing poorly, he must be intimated in no uncertain terms of the metrics of performance. He must be given a clear objective assessment. He must be given a criteria as to what his goals are, how he can go about achieving a better performance target. And then, of course, in a given time span, if he fails to hit those targets, then the company can proceed with the termination on the grounds of poor performance. There's another doctrine of loss of faith or loss of confidence, where employers can proceed with termination on that ground, citing it as a reasonable cause. Broadly, these are stigmatic or simpliciter terminations. A stigmatic termination is one that is likely to attach stigma or cause adverse impact to the employee's future employment opportunities. Whereas a simpliciter termination is one where, upon either provision of notice or payment of wages in lieu thereof, the relationship of employment is severed. More often than not, it's very complicated when we get into stigmatic terminations, because the process, due process, and the various safeguards for employees need to be adhered to. Now, uh, if we were once we advised our client, the company here, as to what the different options open to them are, and then of course as lawyers we go through the material and we evaluate and assess the risk associated with say a termination for misconduct, or a termination for poor performance, or a termination on the grounds of loss of faith. The immediate question a client invariably has is, what is the possibility of such an action being challenged? And this is actually a very important part of the process to understand, as to, once your client has terminated, once an employer has terminated the services of an employee, what then happens to the employee? What is the relief that an employee has? And to understand this process, we need to hark back to our very first foundational question and understand what the roles and responsibilities of that employee or that workman were, so that we're then able to slot them into either a workman category or a workman and employee category. Invariably, every employee is also a workman. Or under the Shops and Establishments Act, there are exemptions created for certain employees who are in a position of management. So invariably CEOs, CXOs, CFOs will fall under that category of persons who are in a position of management. They of course will not fall within the definition of a workman, because as we've seen, the definition of workman excludes those who are in a supervisory activity drawing more than 10,000 rupees a month, or those who are involved in managerial or administrative activities. That being the case, we now fall upon a set of employees whose employment is governed purely by the contract of employment they have signed with the employer. And herein, we have to now understand the jurisdictional risks that are created. Now, insofar as an employee is concerned, as we've seen, Section 39 provides for a right of appeal. Insofar as a workman is concerned, there is recourse to the labor court or the industrial tribunal. Insofar as those who are governed purely by contract, they must go to the civil court. And the nature of relief available to each of these categories is very different. Under the Shops and Establishments Act, the relief that an employee can get in terms of, in the instance of a wrongful termination, is reinstatement but that reinstatement has to be agreed to by the employer. If the employer does not agree to the reinstatement, then a compensation is payable, and that compensation cannot be in excess of an amount calculated at 1 month's pay for every completed year of service. Under the Industrial Disputes Act, the Industrial Tribunal of the Labor Court has the power to mandate reinstatement whether or not there is the concurrence of the employer. Interestingly, the civil court can only grant damages. And this is the most misunderstood part, is invariably a lot of employees, a lot of workmen you may find will file suits for recovery, suits for declaration that the termination was unjustified, and the seeking reinstatement. And it is not uncommon to also come across various judgments and decrees that have granted this, only to then be interfered with by higher courts. There is a specific section which prohibits the jurisdiction of the civil court in granting reinstatement, and that is section 14 of the Specific Relief Act, which bars the specific performance of contracts of personal service. Employment contracts are in the nature of contracts of personal service, and therefore it has been held in a wide range of cases. It's settled position of law today that contracts of personal service not being enforceable, a civil court cannot grant the relief of reinstatement. Instead, a civil court must determine what the damages are in conjunction with Section 73 of the Contract Act, and whatever damages are payable, it can decree the suit to that extent. So, broadly speaking, this is the procedure for termination. This is the relief that that one can obtain at before different fora. One of the interesting things about jurisdiction also is, unlike an arbitral tribunal, for example, which has by way of Section 16 the power to determine its own jurisdiction, the industrial tribunal cannot decide on its own jurisdiction. So, for example, in cases where, as I said, there are certain instances where if a workman has not gone directly to the labor court, but he has gone to the labor commissioner's office, for example, and the labor commissioner or the assistant labor commissioner has facilitated a conciliation meeting between the employer and the workman, and that has failed, and a failure report has been prepared, and an order of reference goes to the industrial tribunal to say that ABC are the issues to be framed and to be adjudicated upon. If those issues are not within the purview of the industrial tribunal by way of the ID Act, then that order of reference itself is open to challenge under Article 226. The Honorable Supreme Court has, in National Engineering versus State of Rajasthan, clearly held that the Industrial Tribunal is a creation of statute. And being a creation of statute, it cannot give to itself powers that the statute does not already confer upon it. So, therefore, these are the broad aspects which need to be kept in mind when we're addressing issues of termination. I will hand over the floor to Trivikram so to open it up to any questions that any of you may have.
Thank you, Mr. Deepak, for a very informative presentation. Now let's move on to the Q&A session. All right, can we have the first online question, please? I think rather we would start with Mr. Harish. Harish, sir, I'm unmuting you. Meanwhile, I'll also check the Q&A box if we have any offline questions. So far, we don't have any offline questions. I'm unmuting Mr. Harish. All right, Mr. Mahesh Babu has a question. Yes, Mr. Mahesh Babu has raised his hand, but I'm trying to unmute Mr. Harish as well.
Hello.
Mr.
Good
Mahesh
evening,
Babu,
sir.
you're on. Yes, you may.
Good
Go
evening,
ahead with
sir.
your question.
So you told about IT workers, sir. Usually, IT workers don't go for this industrial disputes, sir, because they want to join another industry. If there is a bad remark, they want to get the conduct certificate or character certificate. So they want to go as early as possible if there is a termination or retrenchment. So what is your opinion regarding this, sir?
I agree with your reasoning that IT employees usually are extremely focused on their next job. They don't want any adverse character remarks. What I have in my practice found to be very prevalent is that sometimes employers give the employees no choice. They say, look, either you resign or we terminate, in which case the employees fearing a bad character reference or fearing some sort of stigma end up giving a resignation. Then they move to their next job. Once that job is secured, they then challenge the resignation as being coerced. In India, we don't really have a nuanced understanding of the concept of constructive dismissal it's as it has developed, say, in England or in the United States, where essentially a dismissal or a resignation is not voluntary; it's coerced. So I'm finding a lot of these cases in the IT sector, where the IT workers essentially now, with the help of the union, there is, as you know, one says there is strength in numbers. So I think they are a little less fearful of the repercussions in respect of their next job.
Yeah. So one more small this one, sir, clarification. This retrenchment can be because of the improvement in the this one, sir, mechanization or some artificial intelligence modernization. There may be surplus labor,
Yes.
so they go for this retrenchment. So what is
Yes.
your say?
I mean, that's a very important point. Initially, when we looked at the definition of retrenchment, it says retrenchment can be for any reason, a very broad language, and then there are the exceptions. Courts initially had a very narrow interpretation of what retrenchment was and limited it by and large to issues of surplus labor. Now, I think there is a more expansive definition with technology coming in, where it goes beyond issues of surplus labor. What we must remember in terms of retrenchment is there is a statutory safeguard of last in, first out, which means that the person who was last employed has to be the person who is first retrenched. And if there are similar employment opportunities, the retrenched workmen must be offered those. So those are the statutory safeguards already in place in order to ensure that a workman who's retrenched has the ability of continuity of service and is not left out of work for too long.
Yeah. So thank you, sir. Thank you.
Thank you, sir. Can we have the next online question, please? I think I have already unmuted Mr. Mallikarjun. Yes, sir.
Sir, good evening.
Good evening.
Sir, very good evening. Sir, very good evening.
Good evening.
Hello.
I can hear you.
You are audible. You can go ahead.
Sir, very good evening. The presentation was very excellent and right. Sir, I have a question regarding with respect to termination of employees in NGO. Whether the NGO would cover under the IDD Industrial Dispute Act or what is the procedure for termination of the employees in NGO? Even after a full-fledged domestic inquiry, if the NGO employee is terminated, without challenging that inquiry proceedings, whether the terminated employee can go for a civil court for seeking recovery of the damages, or would he directly approach the Industrial Dispute Act for damage or seeking?
Yes. So again, thank you for your question. It's a very pertinent topic. This Shops and Establishments Act applies to NGOs. Section 3 of the S&D Act lists out those establishments which are exempt. Of course, there are certain charitable institutions in respect of providing medical care or care to those who are sick or infirm that are exempt from the S&D Act. By and large, most charitable institutions, most NGOs are covered within the Shops and Establishments Act and therefore have to follow the procedure. Now, even in an NGO, if there is, for example, a case of misconduct, alleged misconduct, the NGO will have to follow the process of giving the delinquent employee an opportunity of being heard, conducting the inquiry. Now, if that inquiry turns out to be against the employee and the NGO goes ahead with termination, the doctrine of election of remedies will come into play, where the S&D Act provides that once someone avails of the remedy under the Shops and Establishments Act, which is for compensation and a fine, which I think is of maximum of 2,000 rupees, then the civil court's jurisdiction is barred. So at that instance, prior to filing an appeal before the Shops and Establishments Authority, the delinquent employee must make up his mind as to whether he wants to approach a civil court for damages or whether he wants to approach the appellate authority under the S&D Act for compensation.
Sorry for interruption.
But of course,
sir.
Yes, please.
Sorry for interruption, sir. Most of the NGOs, the grant in aid received from abroad, given a particular project. See, after project is over, they are employed certain employees for that project only. After that project has been completed, so NGO would not be in a position to continue that employee. So under such circumstances, if the NGO is been terminated such employee, still the NGO would have a right against the employer.
So these usually are now what under the new Industrial Relations Code are fixed term contracts. But on a project by project basis, people are hired. These are consultants; they are not employees. So the first threshold that that anyone approaching the S&D Act would have to seek recourse to is to show that they are employees and not consultants, because a consultant would not get the statutory protection that the S&D Act provides. I'm sure to draw a very loose analogy, the litigation that has now been going on for a few years in the Delhi High Court, where Ola and Uber drivers have sought protection under the labor law, stating that they are in fact employees and they are not entrepreneurs or consultants or for hire workers. I think the first threshold that any NGO's employees will have to prove, whether they go to the S&D, whether they go to the civil court, is that relationship of employment must first be demonstrated, failing which the cause of action will not arise.
Thank you. Thank you very much. Thank you.
Thank you, sir. Now we have Mr. Harish. I have unmuted you, sir. You may kindly go ahead with the question.
Yes, sorry, Trivikram, I think I didn't see the unmuting that time. Okay.
That's okay,
thank you, Deepak. See, I have in the present COVID scenario, okay, if you remember, under the Disaster Management Act, MHA issued an order that wages should be disbursed to employees without any deductions. Wages are paid under the Payment of Wages Act. Employees, suppose in an employee's contract, if there is a power for the employer to unilaterally amend the contractual terms, and then can under such unilateral terms being amended, can the employer terminate the employee because of this COVID reason, and also not pay wages, though he may be eligible for payment of wages under the Payment of Wages Act, which says anybody below 24,000 will come under Payment of Wages Act. Anybody above 24,000 may not come under the Payment of Wages Act. Such unilateral amendment to the contractual terms will it entitle them to terminate the employee, and if such power is given in the employers and employees contract.
Thank you for that question, Mr. Harish. I think let's separate for a minute the issue of wages and the issue of termination. Under the Industrial Disputes Act, of course, there is Section 9A, which provides for notice of change. Any change in the terms of service of a workman must be proceeded with only after 21 days notice is issued. Now, in the absence of that notice of change, any change which is effected is null and void. It's void ab initio. That has been a well-settled position of law. Now, insofar as the MHA's direction was concerned, I did not find the direction to pay wages controversial. Of course, there were subsequent directions to not terminate employees, which I thought was not legally sustainable. And that is a view I still hold today, that it's not legally sustainable. The government cannot tell private employers who to employ, who not to employ. That is part and parcel of Article 19. And the Supreme Court has also read that into contracts of employment time and again.
Thank you.
So without the process of law being followed, Disaster Management Act notwithstanding, it would not be legally tenable in my view.
Thank you.
Thank you, sir. Do we have any more questions? I think I'll have to unmute Mr. Mallikarjun. Yes, he's muted. Do we have any more questions before we wind up today's session? I think that's about it for the day, Mr. Deepak. So once again, on behalf of Advocates Association Bengaluru, my sincere thanks to you for a very informative presentation. Thank you so much.
Thank you, Vikram. Thanks, everybody. Been a pleasure.
Thank you so much. With this, we'll be signing off today's session.